Hi and welcome everyone to this webinar on human rights, dementia and supported decision making. My name is Craig Sinclair and I'm going to be facilitating a number of these webinar sessions over the coming weeks where we describe some of the research findings and also present some of the resources developed through our project on supported decision making in the context of dementia. I'd like to acknowledge the traditional owners of the land that we're meeting on, and people are coming in from around Australia. I pay respect to elders past, present and emerging from those lands, and I'd also like to acknowledge the Cognitive Decline Partnership Centre for their support of this research and for this webinar series. We're delivering the webinar through the Redback conferencing platform, and so if you have any technical or audio issues, you'll notice that there's a comment box on your screen. You can use that to type in and communicate with the Redback team. And you can also use that comment box to enter questions, and we will endeavour to answer those questions at the end of the session. As I said before, my name's Craig Sinclair. I'm at the University of Western Australia. I'm a social scientist and a research fellow. And I'd also like to introduce our guest today, Associate Professor Meredith Blake from the University of Western Australia, who's also an investigator on this research group. Now, just to note before we move on that there is a handout that's available, and you can access it through the comment box or in the documents section, and it is a single A4 page and it's a case study of Ruth. So Ruth is someone who we'll refer to during the session. It'll be on the slides as well, but we've just got it there for you so that you can have access to that. All right, so as I mentioned, this is a webinar series, and across this series we're delivering some of the content that talks about our research findings and also some of the resources developed through this project. In webinar 1, we give an introduction to the human rights basis for supported decision making and how that relates to dementia. In webinar 2, we're taking a much more practical approach and looking at how do we actually support people in decision making in the context of dementia. And this draws on the research that we've undertaken with people living with dementia, care partners and professionals in the sector. And in webinar 3, we're focusing on some of the issues around implementing a supported decision making approach, particularly in the aged care setting, but it's also relevant, I think, to other sectors as well. So you can find links to register for those other webinars on the handout and also on that web link that's given at the bottom of the screen there. That takes you to our project webpage where you can register for those, and I hope you can join us for all of those webinars. Today we're focusing on human rights, dementia and supported decision making. So as I said, we're trying to give a bit of an introduction to the human rights approach and actually then situate supported decision making within this human rights approach so that you can understand, at least at a basic level, how this works and how these ideas fit together. Meredith will also touch on substitute decision making and the legal context in Australia, noting that there are different laws across different jurisdictions in Australia. So we will talk at a conceptual level about some of the legal concepts that apply and how this relates to supported decision making. We've got a video to show and there'll be a case study to discuss as well. And at the end we will take questions, so type them in as you go using the comment box and we'll answer as many of them as we can. Now, first of all, I'd like to introduce the case, which is about Ruth. And I'm just going to read through it now, but keep it in mind as we go through the session because we'll refer back to it and we'll deal with it in more detail at the end. So Ruth is 79 years old. She's lived most of her life in a regional town. Following the death of her husband, her difficulties living alone became apparent. And following concerns from her children, she's had investigations and has been diagnosed with dementia. She has 2 sons and takes great pride in her close family. She's agreed to relocate to the city to live with her son Stephen and his family. After a few months, this arrangement has become unworkable for Stephen's family and Ruth has been moved in to a residential aged care facility. At Stephen's request, Ruth has made an enduring power of attorney, appointing Stephen as her financial substitute decision maker. Stephen has made a number of medical decisions on her mother's behalf based on what he judged to be in her best interest. He did not consult Ruth on these decisions. And Ruth has previously expressed that she never wants to live in a home, but appears to believe that she's currently staying in a church camp. Her son has not challenged Ruth's perception. So just keep this case in mind as we go through some of the concepts today, and we will refer back to that at the end. Now, I wanted to touch on decisions and decision making before I hand over to Meredith, but I think what I'm trying to illustrate here firstly is that while human rights may seem a lofty and theoretical idea, we do have a very good personal sense of what they are when we experience them being interfered with or breached in our own situation. So if we were to reflect on our own lives and think about all the decisions that we make in living our preferred lifestyle, such as decisions around our health, our sleep, our clothes, family, food, holidays, work, budget, and home decisions, we can see how important it is to be able to make decisions in order to live the lifestyle that we take for granted, basically. So we've got a short reflective exercise for you here, and we're going to do a poll. And the poll asks you to stop and think about your own life and say, how many decisions do you think you've made so far today? So you've got some multiple choice options there, and I'll just give you a few seconds to respond. Okay, so we can see some responses coming in. And reflecting in this way, I think, illustrates the importance of decision making in our lives, and also challenges us to think about what it would mean if we were removed from decision making about these sort of domains. So that illustrates the importance of decision making in any human rights approach. Now we'll stop the poll, and you can see there that 70% of participants have said more than 20 decisions they've already made today. So you know, we've coming up to mid-morning, and people are certainly have made a lot of decisions already in just the one day. So I think that's a good way of just situating this in terms of its importance in our lifestyle. And I'll hand over to Meredith now, who will start by giving a bit of a background to the concept of human rights and how that relates to this topic today.
Thank you, Craig, and hi everyone. What I'm going to seek to do today is to show how human rights as a concept are actually protected by the law. The concept of human rights as a protection of fundamental human values actually originated at the conclusion of World War I, when there was a recognition of the terrible atrocities which people committed against other humans. Human rights relate to a range of characteristics and activities, entitlement to which is based around simply being human. And in this respect, you may hear of human rights being referred to as universal, and that's what that means. You may be familiar with some human rights and recognise that there is a right to freedom of expression, the right to be free from torture and inhuman treatment, the right to a fair trial. So you may be familiar with these. You may also think of the right to personal autonomy as a human right. In fact, in many human rights documents, we find this expressed as a right to respect for private and home life. And in this respect, it has been interpreted as including a right to make decisions about matters that impact on your own lives, including medical treatment and sexuality. Now, as Craig said, as an individual, you may have a personal sense, a strong personal sense, that your human rights have been violated in a particular situation. This is a kind of instinctive feel that we have when we feel that our rights have been interfered with. And a person may feel that they've been interfered with by another individual, by a government, either through the introduction of a law or the enforcement of a policy, or even through another public institution or body, again, perhaps through the application of what seems to be, let's say, a discriminatory policy. However, it is important to now look at human rights and its association with the different legal frameworks. Human rights as a concept can be understood to be something theoretical and lofty, as Craig said. It is a seductive idea. But if human rights are to mean anything, we need to be able to enforce them. And that is where we need to now move to looking at the different legal frameworks that we have in relation to our human rights. So legal frameworks can be international. For example, if they're created through the United Nations. They can be regional, which may involve a number of countries in a region agreeing to human rights, and they may be national, and we tend to refer in the law to these as domestic human rights agreements. Some example of international human rights agreements to which Australia is a signatory include the original United Nations Declaration on Human Rights, the United Nations Covenant for the Protection of Civil and Political Rights, the Covenant for the Protection of Economic and Social Rights. Now these are general human rights agreements, but we also are a signatory to other agreements which protect certain groups of humans because we recognise them as being particularly vulnerable, and these include children and those who are suffering from a mental illness. It is worth making the point now that while many countries have decided to introduce legislation so that human rights are directly enforceable within their country, Australia has not done this. So Australia has no national human rights legislation. But that does not mean that a citizen in Australia can't take action to enforce their human rights where they feel that this has been violated. And if we just move to the next slide now, you can see that if a person is seeking to successfully claim a violation of one of the human rights protected under an international agreement to which Australia is a signatory, then this is a process. So a claim would be lodged with an international court, and there would need to be, firstly, a recognition that the situation involves the right in question. In other words, that the situation which the individual is referring to does invoke that particular right. Let's say, for example, the right to freedom of expression. Then there needs to be a finding that the right has been breached by the action or indeed inaction of usually a government law or policy or an action of a public body. There would then need to be a conclusion that even if there has been a recognition that an individual's human right has been violated, that it is not justifiable in the circumstances. And in this situation, the court generally refers to whether or not there is a public interest reason for violating that person's human right. And even after this conclusion, the court would then need to determine whether or not that breach is disproportional, so that, for example, the interference with the human right is disproportionate as compared to the public interest reason for violating that human right. So that's the legal process that a claim for a violation of a human right involves. And if we have a look at the next diagram, the next slide, you'll see that I've used the illustration of a hanger to demonstrate how the legal framework operates. So rather than having these rights floating around in the free air, what the legal framework does is it provides a structure upon which those rights can be hung, and therefore provides a means to enforce these rights. So it does give meaningful application to the human rights documents. Now, if a person successfully claims that a human right has been violated in their case, this may require different things. For example, if the claim is that a person has been actively interfered with and violated in that sense, for example, that they have been detained in a way that is unlawful under a human rights agreement, then that requires the government or the public body to desist or stop actively interfering with them. However, it may also require positive action by another person so that an individual's human rights be recognised. And this is very important when we come to talk about people with disabilities, because people with disabilities often require others to take positive action so that they can enjoy the fundamental human rights on an equal basis with other people. For example, somebody with a cognitive impairment may have their decision-making ability affected by that impairment, and from a human rights perspective, we would say that this requires action to be taken in order that they can exercise their human rights to make that decision or be involved in that decision. So just moving to the next slide. The United Nations Convention on the Rights of Persons with Disabilities is a convention to which Australia is a signatory. It does not create new rights, but rather it states that parties to this agreement have an obligation to ensure that people living with disabilities can enjoy all those fundamental rights on an equal basis with others. And importantly, it has been recognised that people living with dementia are living with a disability, and therefore this convention is very important to these persons. Key to the convention is Article 12. It's regarded as the heart of the convention. It states that people with disabilities have legal capacity on an equal basis with others. And this has been interpreted as requiring that parties to this convention provide people with disabilities with the support they require so that they can exercise this legal capacity. Just turning to the next slide before I hand over to Craig. This is a diagram, obviously, of showing those countries which are signatories to the Convention on the Rights of Persons with Disabilities and to the optional protocol, which enables an individual to bring a claim under the Convention. And you can see from this diagram that Australia is a signatory both to the Convention and to the optional protocol, and therefore that under international law we are required to adhere to the articles in that convention, including Article 12. And I'll now hand over to Craig.
Thanks, Meredith. Okay, so thanks for that background, which gives us a sense of the concept of human rights and helps us to think about what this actually means in terms of implementing a human rights informed approach. Now, I want to talk to the idea of supported decision making and try to explain how that fits in. First of all, in order to do that, I want to give a little bit of history, and that will draw on disability theory to some extent. So supported decision making became prominent in the 1980s and 1990s, mainly in Canada, and it has been developed predominantly through the disability sector. And it was motivated by work that was going on in this sector and a desire to support the autonomy and agency of people living with disabilities to exercise decision making in their own life. Now, the reason that disability theory is really important here, I think, is because one of the central concepts is about delineating between impairment on the one hand and the disability associated with that impairment on the other hand. So we can think about impairment, which might be, in a practical example, it might be someone living with a physical impairment that's associated with a spinal injury, and it means that that person is unable to walk. So their impairment potentially places barriers in the way of their full and effective inclusion in the community. However, with accommodation and with support from the people around them and from the society around them, with access to wheelchairs, with wheelchair ramps, with lifts, that person is not necessarily disabled on the basis of that impairment. So just drawing the distinction between impairment and disability, I think, is important here. That's a very tangible and physical example. When we're thinking about a person with a cognitive impairment, the support and accommodation is perhaps less tangible and less easy to define in a practical sense, but that's really what our job is in supported decision making in the context of cognitive impairment, is supporting and accommodating a person's impairments so that they are able to enjoy their rights to decision making. All right, so we're going to illustrate that in a bit more of a practical sense now with the help from Teresa Flavin, who's a dementia advocate, and she appears on a video that we've created to explain about how she understands supported decision making in her own life. So can we roll that video, please?
My name's Teresa Flavin. I was diagnosed with dementia roughly 7 years ago when I was in my mid-40s. I have 5 children and a selection of grandchildren and animals, and I'm living with dementia the very best that I can. The most important part about continuing to live with dementia is to take an active role within my family. I felt like I was always the head of the family. I recognized very quickly I needed some support with understanding just how I could continue to run a house, how I could continue to be a mum.
I'm Maeve, I'm Teresa's daughter, and I'm 14 years old and I love to ride horses. Since my mum was diagnosed, things have changed a lot. I try my best to help as much as I can while she's, helping out with her work, or I try my best to keep on top of the animals so she can spend more time to rest, so then the next day she'll be really well.
Supported decision making is when I don't have to try to make every decision by myself.
To me it means helping and supporting another person making a decision without making it for them, by showing them different options, the consequences of certain decisions and how well certain decisions will turn out, and supporting them through the decision instead of making it for them.
Everyday decisions, from the big decisions of how I choose to live where I live, who takes care of me, who helps, all the way to small decisions like, what are we having for dinner today? Would I like to go for a walk? Simple as that, and big.
Even things as little as deciding on what feed my horse is going to get for the day. We need to discuss it and talk through, we both have different opinions on what we think he needs for horse food, but we come to an agreement and then we decide together.
Sometimes I need some help, for someone just to remind me that if I want to ride the horse, it's always a good idea for someone to be with me. Part of supported decision making in my daily life is things like that, reminding me of the little things that my brain no longer takes into consideration. Gradually we just embedded it into the way we live our lives, so that all the decisions are more of a cooperative now than me just making every decision by myself. I can no longer be the head of the family in the same way, but with support I can certainly maintain the role at the best I can. Supported decision making was a journey of knowing and understanding the people that I was making the decisions with. The people who were supporting me got to know me in a way that was probably deeper than I expected. It's about giving the person with dementia the opportunity to express their wishes in the best possible situation. Often the decision may need to be broken down into discrete parts to help us to make it, and to make that bigger decision in stages.
I always have to be on the ball to remind her a lot, but I'm prepared to do that and help her just live life as normally as she can.
Supported decision making is not new. It's something that we do every day in our lives with everyone in our lives, whether they're older, younger, disabled, or at any type of disadvantage. Social engagement, engaging with people, engaging with your family, it's important. It's how you build your relationships. I'm very devoted to putting the words out there that there is more to dementia than compassion and concern and well-meaning, you can engage. You can still engage quite far into the disease. You can still get snippets of the person that can help you guide a decision. And I'm very passionate that that gets out there and people are helped.
We spend more time together now. We do more things together at home. We spend time with the animals together. Even though my mum has dementia and she's not well, she is by far the most incredible mum that I could ever ask for, and things like that should not affect how a person is treated, or even things like decision making. Decisions shouldn't be made for her, she should be helped in making her decisions.
Okay, so I'd like to acknowledge Teresa and her daughter Maeve for their role in that video, and for being so generous and candid with their experiences as well. The one point, and there's a lot in that video, but the one point that I'd like to just draw your attention to really is where Teresa says that supported decision making in her view is about a person who's living with dementia having the chance to express their wishes in the best possible context. And that really triggers us to start thinking about decision making as not just something that occurs within one person's mind, between the ears of one person if you like, but something that actually occurs in the context between different people, and that a decision-making process can be actually facilitated by an enabling context, a supportive context. So I'm going to now try and define what we mean when we say supported decision-making based on what we've seen in the video there. And so the United Nations has given a definition where they say the process whereby a person with a disability is enabled to make and communicate decisions with respect to personal or legal matters. And you can see from looking at this definition immediately that it's a very, very broad definition. It doesn't instruct us as to what that support actually looks like. And that's obviously because people have many different types of impairments, and the decision-making scenarios that they're faced with are also very unique and individual. And so we need to really think about a person's individual context when we're designing some sort of support for their decision making and tailor it to their own needs. The other thing I want to just point out is the use of the term supported decision making and its formal use with what we might think of as a capital S, supported decision making. That's something that comes to us through the convention and through legal terminology, but it requires more than just the practice of helping a person. It actually refers to a set of frameworks that enable a person's will and preference to be respected in decision making. Now in Australia, as we'll talk to later in the presentation, we don't currently have a consistent legal framework for supported decision making, but what we can do on a daily basis is provide support for decision making, and that's a term that you might hear other groups using as well. We refer to that in this context, and particularly as these webinars move on, we're looking at the practical aspects of support for decision making. So what does that mean? It means looking at some basic principles that might guide our efforts, such as that this is a voluntary process. It's about the person's own decision. It's assisting a person to understand, to weigh up the options available to them, and to communicate a choice in some way, which may not necessarily be verbal. It's also about potentially developing a person's decision-making ability for future decisions and creating enabling contexts in which decision-making is easier to navigate. Okay, and I'm going to hand over to Meredith now, who will talk a little bit more about this in the context of our current legal frameworks.
Thanks, Craig. This next slide, decision-making continuum, is really a way to depict the spectrum along which decision-making takes place. Now, forefront of the screen we have the independent decision-maker. this is a person who, we say in the law, has the capacity or ability to make that decision on their own. But it doesn't necessarily mean that they will make it on their own. In fact, they may choose to consult with other people in making their decision, and in fact that's common and very natural. But in terms of a human rights perspective, the person who can independently make a decision is regarded as someone who is able to exercise their human right to make decisions and their human right to full legal capacity without any assistance. If we move further along the spectrum to the middle of it, we see here that we have people who are being supported to make decisions. Now these are people who can't make an independent decision, but they can be supported so that they are participating in the decision that is being made. And in terms of a human rights perspective, we would say that for persons who don't have the capacity to exercise independent decision making, it's very important as a matter of human rights that they be given the help that they need so that their wills and preferences and rights can be enjoyed by them. Then we move towards the rear figures, which is referring to substitute decision making. Substitute decision making is where somebody else makes a decision on behalf of the person who lacks capacity or the ability to make the decision. We regard this as a situation of last resort, but as you can see from the quote on the slide, it has been recognised that it is a reality in many situations. But in terms of how we regard it in this presentation, we'd say it is a situation of last resort. But as it does happen, it is important for me now to set out the law in terms of substitute decision making, where somebody makes a decision on behalf of another. And I should point out at this time that when we're talking about making decisions, we're not just talking about a decision to say yes. We're also talking about a decision to say no. So it is about the decision to say, yes, I want to do this, but it's also about the right to refuse. And we see this in connection, for example, with the right to refuse medical treatment. As Craig's indicated, we don't have consistent laws throughout Australia, but what every jurisdiction in Australia, every state and territory does have is that they have guardianship legislation. And this guardianship legislation provides for other persons to legally make decisions on behalf of another person. Now, this may occur if a person is appointed by a tribunal or board, but it may also occur where a person makes that decision as someone who is regarded under the legislation as a person responsible. And that is usually a close relative or a carer. And all of the legislation sets out the people who qualify as a person responsible in a hierarchy. So the law does provide that others can make decisions on behalf of a person who lacks capacity or the ability to make the decision. The next question is, on what basis do they make those decisions? And there is some difference in the laws across Australia here. Most jurisdictions prescribe what's called a best interest test. And this is where the substitute decision making is making a decision which they think is best for that individual. And it is about the individual. The other approach which we see in Australia less commonly is where the law says that the substitute decision maker needs to step into the shoes of the person who lacks capacity or ability to make the decisions. In other words, it requires a decision maker to make the decision which they think that person would make if they had the capacity or the ability to make it. And at this point, I'm going to hand back to Craig.
Okay, so this is we're just going to run another short poll here, which is particularly relevant to those who are involved in service provision. So if you're providing care or you're involved in providing services for people living with dementia, the question is, what proportion of your clients would predominantly, and by that I mean more than 90% of the time, use an independent or supported decision-making approach for decisions about their care and lifestyle. It's a bit of a head scratcher, that one, and as you think about your own situation or your own service provision, it will also illustrate how this is not a black and white situation. People don't just fit into particular boxes, but we're talking about predominantly and of course the nature of this decision making is likely affected by the severity of a person's cognitive impairment, the types of decisions that they're encountering, and the setting in which those decisions are being made as well. So the variation in responses here is perhaps indicating that. All right, so we have our responses in. So are those results available? Okay, so you can see there that there is a large variation in the answers given, and some people are saying that it's almost none, and some people are reflecting that almost all of their clients. And again, I think this really reflects a variety in settings. It's not necessarily you know, a bad thing if a person is having some substitute decision making, but as Meredith has outlined, there's a process by which that happens, and we understand it as a last resort. Okay, so I'm going to hand back to Meredith now, who will take us through some of the other legal concepts that apply here.
Thanks, Craig. So now I want to talk a little bit about decision-making ability, and in the law we tend to use the term capacity, although ability may be used in more practical sense. As I've indicated, a person with decision-making capacity has the right to say yes and the right to say no, but the law has set down requirements which are set out by the law, determining when a person has the capacity to make a decision. And that's depicted on this screen. Firstly, the question is asked, can the person understand the information relevant to the decision? Secondly, are they able to retain it long enough to use it in making a choice? Are they able to weigh it, for example, to weigh the risks and the benefits associated with making that choice? And are they able to communicate it in some way? And this isn't limited to verbal communication. It could be through gestures or, for example, through blinking. Now, capacity is not the only part of making a legally valid consent or refusal of treatment. The law also says that a person must make that decision voluntarily, and that the person may make that decision based upon fundamental information which is important to that decision. And this emphasises the role that decision-making plays in the law as a matter of human rights. That if a person has the capacity, if they are making the decision voluntarily and they are making it on the basis of the important information surrounding that choice, then they are exercising their right to personal autonomy in making that decision. Now, if we just move to the next slide, this is dealing with the situation where a person, while they have capacity, is seeking to plan for a time when they don't. So many decisions, and you out there will have made many of these today, you make in the here and now, in the moment. But people may recognise that if there's a time in the future when they lack capacity, that they would like certain things to happen or not happen. And to that end, the law does provide mechanisms to achieve this. If you have a look at the top, the Advanced Care Directive, this is where a person who currently has capacity executes a directive, essentially saying what they don't and don't want in terms of healthcare decisions when they or if they come to a point where they lack capacity. Also on the top you see there the enduring power of guardianship. This is where a person chooses another to make decisions about their health and lifestyle matters at the point where they have lost capacity. Down on the bottom you have the enduring power of attorney. This is another situation where a person exercises their autonomy by appointing a chosen person to make financial and property decisions for them once they have, or if they have, come to a point where they lack the capacity to do so. I'd like to distinguish those three situations from the will, because the three situations that I've already referred to, the Advanced Care Directive, the EPG and the Enduring Power of Attorney, are all about planning for what happens in a person's lifetime. The will, of course, only takes effect on a person's death. And I think now that I'll hand back to you, Craig.
Yes, thanks. Okay, so just building on what Meredith has been talking about there, we have heard already about this idea of substitute decision making and the basis upon which those substitute decisions can be made as a last resort when a person lacks the decision making ability and possibly through a best interest approach or stepping into the shoes of the other person. And that really describes at a conceptual level what we have in place in terms of our laws in Australia. The new information and the new ideas that we perhaps have to accommodate and look to understand and implement associated with the Convention on Rights for People with Disabilities and this human rights approach talk to the idea of a person's will and preference. And that's a way of understanding people's wishes, but the fact that our wishes have different components to them. So we can think of the person's will reflecting their longer term interests and perhaps their values and the things that they would reflect on as representing their idea of a good life, and what's important for me is a way that some people have conceptualized that. But also we also incorporate in here preferences, which is a person's more momentary desires and impulses and the choices that they reflect if given an opportunity. So the things that people will express as being what's important to me, perhaps more in a momentary sense. And part of the craft of taking a supported decision-making approach, I think, is actually operating in this will and preference approach, which asks, what is it that the person is really wanting here? Can we support them to express their will and preference, and then can we respect that will and preference? And in the case where it's either impossible to understand what a person's will and preference is, we might then fall back onto an understanding of their human rights that would be relevant to that situation. And that's always a process of balancing, because while we have a right to things like autonomy in making decisions, we also have rights to other things such as shelter, privacy, those sort of human rights as well. So it's an act of balancing in that case where we're unable to determine a person's will and preference. Now we're moving on to revisit Ruth again, and as you'll recall, you may have the handout with you, but you remember that Ruth has been diagnosed with dementia and she's moved from her regional town to the city to live with Stephen and his family. After a short period of time, that wasn't working out and she's been moved into a residential care facility. And along with that process, we understand that an enduring power of attorney has been set up. We're not quite sure about the process under which it's been set up, but Stephen has been appointed. And we also know that Stephen has made a number of medical decisions on Ruth's behalf on the basis of her best interest without consulting her. So the question is really, what is going on if we look back at some of the concepts we've covered today, what's going on in this case, and what might it look like if we were looking at supported decision making for Ruth? So firstly, we can say that there has been substitute decision making going on in this situation. So for example, Stephen has made some medical decisions on Ruth's behalf and he's taken a best interest approach. It's questionable as to whether the extent to which he's authorised to do that. Certainly the enduring power of attorney doesn't give him the rights to make those healthcare decisions, but he may be acting as a person responsible in this case. Even in a situation where he's acting under a best interest framework, we would argue that that always incorporates taking into account the person's wishes and working through with them what it is that they would want. But I think if we were to go further and look at what a supported decision-making approach would look like, it actually requires us to delve deeper into the decision-making that's gone on here, to understand what are the choices that Ruth has been offered, what does she understand of those choices, and how has she been supported to work through those decisions and to express her own views. Now, I don't think that anyone would argue that there's a human right that enforces Stephen to accommodate Ruth in a situation that's not workable. But where the rights would apply would be in terms of Ruth having access to a chance to express her views and to be supported in looking at the different options that might be available. So there may well have been other options for her accommodation and for home care as well. As we look at the will, preference and rights approach, we need to think about this approach of actually understanding what is Ruth's will and preference here. So if we think about Ruth's will, that might reflect aspects of what she stated about her goals and values. She did say that, well, she's expressed that she takes great pride in her family relationships, but also she's expressed in the past, and this is perhaps more of her preferences about not wanting to be in a home. So as we can see there, sometimes these things do conflict, and the role, I guess, of someone who's working in this approach is to actually help to clarify what the person's will and preference is. And finally, the issues around the setting up of the enduring power of attorney actually point us to what was the process in supporting Ruth in making that decision. Was it actually a voluntary decision? And if not, what does that say, I guess, about the basis on which that decision was made? So Meredith is going to talk a little bit to that point.
Yeah, I'm just going to explore quite briefly a couple of the legal ramifications pertinent to the principles and the human rights issues that Craig's identified. He's referred to us not knowing about the process by which the EPA came about. And this is very important legally because in all jurisdictions where we have guardianship and administration legislation, there is a requirement that the person have capacity when executing an EPA, and we don't know whether or not that was complied with in this case. Another thing that arises in relation to the EPA, Craig briefly there referred to whether or not it was carried out voluntarily. There is some question here about the circumstances under which this came about, and particularly as we know that Ruth has been is now a resident in an aged care facility, and there are policies which do seem to require that incoming residents have executed these sorts of legal documents, and therefore we need to question whether or not this decision to appoint Stephen as an EPA, not only whether or not Ruth had the legal capacity to do this, but whether or not Stephen was in fact doing it voluntarily himself. So while the EPA legally is designed for a person to retain control over decisions made about their finances and property once they no longer have the capacity to do so, it's clear that it may in fact unintentionally interfere with this objective. Secondly, in relation to the decisions which Stephen's made about Ruth's health, the medical decisions, it's clear, as he's pointed out, that he hasn't consulted her on these. And I think it's important to note that he hasn't been appointed the enduring power of guardianship, which under the law entitles him to make health decisions. Craig said that perhaps he's making them as a person responsible. But even so, under all of the legislation, even those jurisdictions which apply a best interest test, there is a requirement legally for the decision maker to consult the person where that is possible. And so there is clearly a legal issue here. If this law was in a jurisdiction where there is a requirement that the decision maker step into the shoes of the person who now lacks capacity, that obligation obviously is even greater. The final point that I'd make is about the decision to move Ruth into the aged care facility and her belief that she is staying in a church camp, which her son has not corrected her on. I think that this raises a legal issue about the power of substitute decision makers. Very clearly in the law, somebody who is has been appointed as an EPG or who is acting as a person responsible can make medical decisions and broader healthcare decisions. But there is far less certainty as to whether or not this would include a decision about where Ruth is to live. So those are the few things that I have to offer from a legal perspective. I'll hand that to you, Craig.
Thanks, Meredith. And finally, in terms of practical strategies or what might be a response in this situation, I think that keeping in mind that idea of anything that overrides Ruth's will and preference being done only as a last resort, and the human rights approach also talks about when this is done, that it's done in a least restrictive way, in a way that's tailored to the individual's situation and proportionate to the risk to their other rights. So only just enough in terms of what's needed to protect them from those other risks. The other point about Ruth's decision-making ability is that we haven't, through not consulting with Ruth, we actually really don't have a good idea about what is her ability to make these decisions, and I would promote the idea of decision-making ability being used here not as a means of excluding Ruth from the decision, but as a way of understanding what it is she needs in order to facilitate her inclusion. So what is it that she needs in order to support her ability to express a will and preference? Acting early is always going to be, I think, helpful, and in this case Stephen's actions might be the product of a lack of awareness of his responsibilities. So what can we do to support Stephen in his role? And I think creativity is going to be an important factor as well. So what can service providers do creatively to actually develop other options that are going to meet Ruth's needs? And just referring quickly to the issue about the policy of some aged care providers in requiring that these instruments, the enduring power of attorney particularly, are completed before a person will be admitted. I think there's a role for advocacy here to say that this sort of policy is actually, I think, not in the spirit of these instruments, which were designed to respect a person's wishes rather than to be enforced in a way that everyone has to complete them. Okay, so I'm just finally going to finish up by looking ahead. We've got, as I said before, no consistent legal framework for supported decision making, but what we do have in Australia has been a national level response to the Convention on Rights of Persons with Disabilities, and the Australian Law Reform Commission has given us a number of recommendations and a set of national decision making principles, which it's argued will actually inform the future process of lawmaking at a Commonwealth level, and they're also being used at a state level in reviews of different legislation, such as, for example, the guardianship review in New South Wales that's underway at the moment. Other things that might be relevant for aged care providers would be the changes to the Aged Care Act around the implementation of a new single quality framework for all aged care providers, which has recently been introduced and is being implemented between now and July 2019. And that includes new standards which actually talk to the importance of supporting a person in exercising choice. So I've just given an example there of Standard 1.2 about consumer choice. And as part of this project, I just want to briefly touch on a guideline that we've produced which brings together the principles from the Australian Law Reform Commission and also ties that to some of these new standards and provides a set of other tools for aged care providers in actually thinking through what does a supported decision-making approach mean in that organisational setting. So it's got tools there for auditing your own policies, a case study to work through some of the issues, and then some guidance on how you might set policies and develop policies in the future. So we have a few minutes finally for some questions, and I just encourage you to submit any questions that you want us to talk to, and we'll do our best to answer those. There's one that's come in from someone who's asking about, regarding voluntary euthanasia, can this be stated in your advanced care plan? In Australia at the moment, and in fact it's very rare around the world, even where euthanasia is legal, for it to be actually enforceable within an advance directive. There's only a few jurisdictions where that can happen, and in Australia it can't happen. You may be aware of the Victorian legislation that does not include the support for a person to put euthanasia or assisted dying into an advance care directive. Did you have any comments on that, Meredith?
Yeah, that's absolutely correct. So the Victorian legislation, Victoria is the only jurisdiction currently where, and I'd say voluntary assisted dying, it has been legalised just last year, and because it requires the person to have current capacity, it therefore has excluded the possibility of including this in an advance care plan.
Okay, and we've just got a question about the presentation slides. So this session will be available as a recording on the web page that was given to you in the handout and also referred to earlier on, and I'll bring that slide up at the end. So if you want to access the material, you can go to that link and view the recording, so it will include the presentation as well as the slides. Okay, and we've got one more question coming in. Okay, so the question is, can this material be used for staff training? What we're doing is actually developing a training package that's designed for use in the aged care sector, and it refers to some of the situations that would be particularly encountered in the aged care sector. I think the concepts can be generalised, and there are other people, of course, who are developing resources, particularly in the context of the disability sector. But that training package is being piloted over the coming weeks, and we will be making those resources publicly available by the end of the year. So when our project finishes, all of that material will be publicly available. Okay, so that looks like if we were going to finish on time, that might be where we have to just leave the questions. Thanks very much for those questions and for your attendance today. I'll just finish by reminding you that these webinars are part of a series, so you will be able to view this session, or if you're passing it on to colleagues, there will be a link to view the session, and you can register for the upcoming sessions where, as I mentioned before, we'll be taking a much more practical approach. So the session on the 13th of August involves Professor Mira Agar, who's a palliative care doctor, and Anne Peach, who's a dementia advocate, and she'll be talking about some of her lived experiences, and we'll also be presenting some of the findings that we've gathered from people with dementia and their care partners on how they actually practically go about supporting a person's decision making. So we think that would be a great session for carers as well. And I think we're going to have to leave it there, but thanks again for your attendance today, and look forward to seeing you at the future webinars. Thank you.